Wait, so I feel for listing admission matters.
Mhm.
Admission matters, matlab next week any day.
Mention next week. Why are you mentioning today?
For next week, today, Saturday.
Next week. Next week not possible. We can have it on 26th. Admission pleadings are exchanged.
Yes, my lord. Notice was issued to my lord 10/5.
No, 25th. 25th.
Yeah, please, also. Paying for listing on face lawsuit. Pertains to the eviction and rehabilitation lawsuit. I'm paying on lawsuit Wednesday lawsuit.
When did you file it?
I have filed on 9 lawsuit. There is no defect. 9 1.
Why can't it be on Monday?
Mondays. I have some defect in my Senate.
You said it is an urgent matter. Then have it on Friday.
First.
May please, Your
Okay.
Lordship, I make to mention for listing of an IA Lordship, I for implement Lordship. Here the collector repetition has been listed on Monday Lordship. And also can it be listed on Monday Lordship because
Alright, Monday.
much of it.
Lordship, the petitioners are elected ward representatives of 3 wards out of 10 wards. Lordship is aware a Gaon Sabha is usually demarcated into 10 wards. So we are elected representatives of 3 wards. That is ward number 3, 7, and 8. Now what we are aggrieved by is Lordship page 22. This is a notice convening a meeting of the Gaon Sabha. And Lordship, the dates are important. It's issued on 13th January 2026. And it says, this is, Lordship has page 22. This is to inform all the people as well as the members of the Bawarghat Gaon Panchayat that on 15/1/26 Thursday, that is today, Thursday at 1 p.m. a Gaon Sabha meeting will be held in the premises of so-and-so building. And Lordship, the agenda for the meeting is important. Decision and approval of annual action plan of 5th Finance Commission for the year 2024-25, 25-26. So Lordship, they've given a 1 day's literally notice, 13th, for a meeting on 15th. And Lordship, that is against the mandate of the law. That's the Panchayat Act. Lordship, page 17 is Gaon Sabha. This is a meeting, if Lordship sees, it's a meeting of Gaon Sabha. And Lordship, we are concerned with 4.4, which is at page 18.
Yes.
4.4. The meeting, Lordship has 4.4. The meeting of the Gaon Sabha shall be convened by the Secretary of the Gaon Panchayat with due approval of the President of the Gaon Panchayat and in consultation with the Block Development Officer concerned, provided, which is important, provided wide publicity is given 15 days ahead of the date of the holding of the Gaon Sabha meeting. So they contemplate 2 things, a 15-day prior notice and wide publicity. And the reason is why Lordship may kindly come to 4.8 functions. It says identification, the Gaon Sabha shall perform the following functions: identification of beneficiaries of implementation of development schemes pertaining to villages. And Lordship may kindly go to page 20. (4)D, which is what are the functions of the Ward Sabha? And the petitioners belong to 3 such ward sabha. They're the representatives of 3 ward sabhas. Lordship has 4D. First of all, Lordship, ward sabha meeting must have 7 days prior. That is 4B2. So if we were to convene a meeting as an elected representative, I have to give 7 days meeting for the ward sabha to convene. 4D, Your Lordship. Powers and functions of the ward sabha. Ward sabha shall, subject to such rules as may be prescribed, exercise the following powers and discharge the following functions. Roman 1, Ward Sabha shall assist the Gaon Panchayat and the Gaon Sabhas to conduct surveys or participatory rural appraisals to collect essential socioeconomic data and assess the needs of the residents and their requirements for the development of the village in order to enable Gaon Panchayats to compile and draw up comprehensive Gaon Panchayat development plans. 2, generate proposals and determine priorities of scheme and development programs to be implemented in the area of Gaon Sabha and forward the same to place before the Gaon Sabha for inclusion in the Gaon Panchayat development plan. So there's a reason why you need to give notice and you need to give publicity so that the Gaon's Ward Sabha can assess their own things, and they would have. And then everybody, the entire 10 wards are represented in that Gaon Sabha meeting, and they then say that this is what we need and what we require. Now, what has happened is pursuant to this meeting that happened without due notice, page 26, page 24, Your Lordship. They have the Gaon Panchayat, the Gaon Sabha, in their meeting have now sanctioned these development schemes. The Lordship, page 24 is 9 development schemes for 24-25. Our 3 ward is nowhere in the picture. And page 25, Lordship, 5, 6, 7 is for ward number 7, group 7, and 9 and 10 is for group 8. But there is none for group 3. And even this is without hearing us as to whether this is priority or not priority. So my limited prayer is that they should reconvene the meeting by giving due notice and wide publicity. That is all that is.
Is it so far as your ward is concerned?
Yes, Your Lordship.
Which is ward number 3?
Which is ward number 3, 7, and 8.
3, 7, and 8. Who's for the respondents?
Representing the department, my lord.
So this is by the secretary of the GP.
Yes, yes.
Probably there is no standing council.
Secretary, I am representing.
You are representing.
President, I cannot, my lord, but secretary, I can.
The notices by the secretary.
Yes, that
It
is bad, my
appears
lord.
to be in conflict with the
Yes.
provisions that you are not maintaining the.
13-1 notice is bad, my lord, yes.
Huh?
Not followed, my lord.
Not
13-1. Admittedly, this.
And get your
1-1.
instructions and we'll remand it back. Hold a fresh meeting.
Today is the designated day for meeting. So he should inform.
My lord, in fact, my lord, page 26, they have filed one representation. Lordship can dispose of the matter,
Yes.
remanding the matter to BDO, my lord.
BDO.
Holding the today's meeting, my lord. This is representation before BDO, page 26.
26. And 27.
Is
27,
Is that-
Commissioner come chairman, my lord.
this is the authority which finally
take the
approves.
call. Who will
Lordship,
take-
we want a fresh Gaon Sabha meeting where we
I
can.
know in the representation, who is going to take the call? Is it the BDO, the district commissioner, or chief executive officer?
Finally, Gaon Sabha
District
president.
Commissioner is the appropriate one, my lord.
DCA को देखो. DC,
District Commissioner.
District Commissioner.
District commissioner.
The Lordship, the Gaon Sabha shall be convened by,
Approved by the secretary.
yeah, but it should be with due approval of President Block Development Officer, 4-4.
Thank you, my lord.
Final approval is by DC.
Where is that? Where is the provision? The final approval is by the DC.
Lordship may have 3, section 3. So this is the constitution of the District Planning Committee. So first the Gaon Sabha meets. Then today's meeting is by the District Planning Committee and 3-8.
This is the notice. Where is the notice for today's meeting?
This, Your Lordship,
No. By
This
the notice at page 22.
that's a Gaon Sabha meeting.
That's a Gaon Sabha meeting.
Yes, that is 4-4.
What
That is
happened
4-4.
in that meeting?
Lordship, that meeting, they will discuss what the plans are. Development plan would be. It says,
Now,
it's
are
called
the
the-
minutes available somewhere?
district, no, Lordship, we don't have. Of
There's
the
no
meeting,
minute.
no. How much
So
of that?
this meeting was convened and it was held, some decision was taken.
Yes, and we were not party to it.
You were not party to it. Now, pursuant to that, what happened?
Now, Lordship, it goes to the District Planning Committee, which is
District
3-3,
Planning Committee.
which will have a draft development plan.
So the district planning committee is sitting today.
Yes. And then 3.8, it goes to the government for approval.
Now assuming that your blocks are 3,
3, 7 and 8. 3, 7 and 8.
3, 7, 8. These are wards.
Wards, yes, wards.
Now these wards, according to you, these wards development projects have not been discussed.
Not we
Or
don't know whether discussed or not discussed. We were not party to it. The representatives of those wards were unable to attend because of no notice.
And who are you in the petition?
We are the elected ward representatives. So every ward has a representative.
How many representatives?
3, each one.
One.
Yes.
So
So,
you are-
so
you are the-
petitioner number 1 is group 3, petitioner 2 is group 7, and petitioner 3 is group 8, and petitioner 2 is group 7. So
So-
3 ward representatives, 3 wards.
So whenever any meeting of the
Gaon Sabha.
Gaon Sabha is constituted, you will represent the ward.
Yes, yes.
And the conclusions or the minutes have not been communicated.
No.
So even if this meeting goes on today, these are with regard to the other wards.
No, it includes everybody. It's a Gaon Sabha. The Gaon Sabha, the Gaon Panchayat is 10 wards. So they have taken a,
According to you, in terms of 22, you are not notified.
yes.
So therefore, in respect of ward number 3, 7, and 8,
Our needs are not,
according to you, there is no information whether any development works have been projected, approved,
approved we know, because that's a list on 24, 25.
24, 25. So these are the approved ones.
Yes. So
So it is
24,
a-
25, we don't find any place. Our wards find nothing,
Nothing.
nothing.
So
And on
this-
25,
Now, this is now to be discussed in today's meeting.
yes, it'll get the district
If-
planning committee. Yes,
Right.
yes.
So in
This gets approved, then work start. The DC gives permission and then work
so
starts.
therefore, insofar as the works of these wards are concerned, at page 24, 25, you are not concerned.
We are concerned because the fund allocation will depend. Our grievances, we should find a place in it.
Your grievance is that along with them, your
Needs should have been
needs
assessed
should have
too.
been
Yeah,
considered.
yes, yes,
Right?
yes.
But can it be a case, it's not your case perhaps, that without considering your needs, these needs could not be considered? Cannot be perhaps. You are concerned with your needs.
Yes, yes.
So
But the allocation of funds is
these
limited.
allocation of funds, whatever it may be, these wards requirements ought to have been in this list.
Yes, yes.
Right? That-
There must be proportionate distribution of the funds amongst all wards, not just 7 out of.
So what we do is we dispose of the petition with a direction to the DC as the chairman of the
District Planning Committee, I think.
district planning committee, that while taking any call in this respect of these development works pursuant to the meeting on page 22, DC will also look into the grievances as to why these representatives were not called for
Also,
the meeting.
DC is not the chairman. The president of the Zilla Parishad is the chairman. That is 3-5. The DC is the final approval, 3-8, is what I understand from the scheme, isn't it? 3-5, Your Lordship, President of the Zilla Parishad shall be the ex officio chairman of the District Planning Committee, page 16. 3-5.
He will be the only the
Yes,
permanent
yes,
invitee.
yes. Our Lordship, 3-8
please-
is where I think
Who
you
will
go
look
to.
into the grievances? That's what we are asking you. You're unable to tell us.
Lordship, that's 3-4, that's 4-4. The Gaon Sabha will meet. We are concerned with 3-4 meeting. The 3-4 is a meeting of the Gaon Sabha. The
So what are your prayers today?
prayer is for a fresh convening of meeting of the Gaon Sabha.
So fresh convening, why should the entire items in respect of other words be reconsidered?
I understand. So
concern you.
what your
This is your
Lordship, yes, I understand what you're saying, Your Lordship, yes. The only thing
Therefore,
is,
that reconvening has to be with regard to your works, and the fund allocation shall not be made.
yes. So DC should be mindful of the fact that our needs were ignored.
Provided he has the power to do so.
Lordship, that is 3-8.
The 3-8
Yes.
chairman of every district planning committee shall provide the
Committee.
My lord, 3-4 3(4) is the chief executive officer of the Zilla Parishad shall be the ex-officer secretary of the committee. Zilla committee, my lord.
No, this planning is by district planning committee
Yes, ma'am.
That's 3 section.
prepared by Zilla Parishad, Gaon Town. Panchayat. The
It shall consist of 2, your lordship. 3(2) is the composition.
3(2).
3(2). District Planning Committee shall consist of, and 3(5) is the president is the ex officio person. But what fell from your lordship probably is the most effective relief we can get, your lordship.
Who will be the chairman of this committee?
Lordship, it says the president of the Zilla Parishad shall be the ex officio chairman.
Where?
3(5), your lordship. Page 16, 3(5).
And 380 saying, my lord, chairperson
Yeah.
will forward to the government.
Government who will approve finally.
Now, is the president of Zilla Parishad a
Particular.
Yeah, a particular.
member here?
This
So, but
this
the
this
president
notice
of
is by the Zilla
Zilla
Parishad.
Parishad is not a government employee. So, is he a government employee?
President is not.
Lordship, he's a party in our writ is
Hmm.
R4.
Chief executive officer of the party, not president, ma'am.
The chief executive officer,
Is the secretary.
secretary.
Yes.
Yeah.
Ex officio.
We will direct him. But NSG Goswami, Government Council, petitioner, Mr. S. Doctor, for respondents, number 1, 2, 4,
My lord, 1,
5,
2, 4, 5, and 6.
6. And Mr. N. Das, responding number 3. The petitioners, the petitioner for the court tend to be project themselves to be the elected representatives of ward numbers 3, 7, and 8 respectively, under which GP?
Bawarghat, Gaon Panchayat.
Gauhati, Gaon Panchayat, in the district of Hailakandi.
Hailakam. District of Hailakam.
The petitioners are aggrieved that by notice dated 13/1/2026, the Secretary Bawarghat GP informed the members of Bawarghat's Gaon Panchayat that on 15/1/2026, the Gaon Panchayat Sabha will be held in the premises of Pichinga ME School for discussion of the agenda mentioned in the notice. The agenda is primarily for decision and approval of the annual action plan of the 15th Finance Commission for the year 24-25, 25-26. The Learned Counsel for the petitioner submits that this meeting essentially is to take up all the development projects in different wards, and on the basis of which the same are to be forwarded to the District Planning Committee, and if and upon approval of such, the same shall be forwarded to the government. The Learned Counsel for the petitioner, referring to section 4, capital B, submits that sorry,
4.
4 submits that the meeting of the Gaon Sabha shall be convened by the secretary upon due approval of the president of the Gaon Panchayat in consultation with the block development officer, then be given wide publicity 15 days ahead of the date of holding the meeting. So, as the counsel for the petitioner submits that this is the prescription of the statute, that the notices are to be issued 15 days ahead of the meeting. However, by the impugned notice, only 1 day's time was granted, and and the petitioners could not be present in the meeting. So, as a consequence thereof, as per information available, the development projects which are listed as annexures B1, B and B1, the red petition, where the issues which were discussed and approved, so these development projects, according to the petitioners, do not pertain to wards number 3, 7, and 8.
No, Lordship, page 25 does. 3 and 2.
Hmm?
Lordship, page 25 is for 25, 26.
3 and 2.
5, 6, and 7 pertain to ward. Serial number 5, 6, and 7 is to
5,
ward 7,
6, 7.
is to ward 7,
Hmm.
and 9 and 10 is to ward 8. But these were discussed in our absence. And ward 3 is nowhere in the picture for either of the years.
Learned counsel for the petitioner submits that the projects which are listed at serial number 5, 6, and 7 of the list enclosed as annexure B within bracket 1 pertain to ward number 7, and serial numbers 8 and 9 pertain to ward number 8. So, however, these were approved and discussed. So discussed and approved in the absence of petitioners 2 and 3. However, there is no approval of any project connected to ward number 3. So is therefore submitted that when the statute mandates that the statute mandates that the meeting is to be held 15 days prior, and the Gau Panchayat meeting is to be held by inviting all members of the Gau Panchayats. Therefore, in the absence of the proper notice period, petitioners could not be present, and the items, some of the items reflected in the annexure enclosed were discussed in the absence, which is not permissible. And insofar as ward number 3 is concerned, no development items were at all listed. The learned counsel therefore submits that, as per information available, these items which were discussed in the Town Sabha meeting are required to be placed for approval before the District Planning Committee meeting, which is scheduled to be held today. Sorry, today or tomorrow?
Today, Your Lordship,
Today.
at 12 o'clock.
Today at 12 noon. The learned counsel therefore submits that each of these developmental works pertain to the various wards of the Gau Panchayats, and the elected representatives are and the representatives are elected by the members of the Gau Sabha to represent the needs and the aspirations of each of the wards, and therefore in the absence this meeting approving these developmental works is not contemplated in the provisions of the Act. Therefore, the proceedings which were adopted in the meeting held on which date was it held? Any date?
Meeting was held on 15, as per 22,
15.
15 January.
15/1, 2026. Is required to be suitably directed to reconsider the claims of these ward members in the presence of the elected representative of the wards, namely petitioners. The Learned Council further submits that in this connection, several representations have also been addressed to the Block Development Officer, Algapur Development of Algapur, the District Commissioner cum Chairman, District Development Committee, Hailakandi, as also the Chief Executive Officer, Zilla Porikot, Hailakandi. So, by these representations, the petitioners have ventilated their grievances. However, same has not been addressed. The Learned Council for the respondents admit that they have no instructions in the matter. However, if there is a direction to respondents, consider the grievances raised in the representations filed, then the writ petition may be disposed of. But having heard subsequent parties and upon perusal of the writ petition, as also the provisions of the Assam Panchayat Act 1994, it is seen that there is no explanation as to why the notice dated 13/1/2026 called for a meeting to be held on 15/1/2026 when, as per section 4.4, is it? 4.4, 15 days notice is required to be granted to the before convening a meeting. That apart, the petitioners are elected representatives of their wards, and their presence was necessary in the meeting to ensure that the development works in respect of their words are taken up in right earnest and such then appropriate approvals and are sent up for appropriate approvals. So from the list of projects which were approved, although some projects are seen in respect of ward number 7 and 8, as pointed out by the Learned Council for the tribunal, it is also submitted that there is no work pertaining to ward number 3. So, and these works which are approved in the meeting are required to be taken up today in the District Planning Committee meetings scheduled to be held today by the notice dated 4/2/2026. And pursuant thereto, and if they're approved, then they'll be sent up for approval of the government. The Learned Council, the petitioners are agreed that they have no idea, they have no information as to the manner in which these works were shown to be approved, so far as ward number 7 and 8 are concerned, and as to why no development projects were taken up in respect of ward number 3. This court, however, is of the view that interference with the minutes of the meeting held pursuant to the notice dated 13/1/2026 in respect of the approvals, in respect of the conclusions arrived at regarding the development works to be carried on, will not serve the purpose will not ensure redressal of the grievances of the writ petition. So, writ petitioners are admittedly concerned with development works for their ward, for their wards. So, therefore, it is the view of the court that ends of justice will be met if there is a direction to the respondent authorities to reconsider the development works in respect of ward number 3, 7, and 8 in the presence of the elected representatives. Thereafter, approve the same if the same are found to be suitable for carrying on the development works. Stop. In this context, if a proper meeting of the Town Sabha is required to be held, then the same shall also be convened in terms of the procedure prescribed under the Act. That view of the matter, this court directs. Although several representations have been addressed to the block development officer Algapur, several representations have been addressed separately, one each to the block development officer Algapur Development Block, Algapur, District Commissioner, Chairman, District Development Committee, Hailakandi, and Chief Executive Officer, Zilla Purikat, Hailakandi. Court is of the view that the directions can be issued to all these respondents to ensure that the grievances of the petitioners are revisited and the meeting of the Gaon Panchayat is reconvened by giving adequate notice to reconsider the claims of development projects in respect of ward number 3, 7, and 8. And thereafter, the same be placed before the District Planning Committee for due approval. So, the meeting scheduled for today, of which a copy of the notice dated 4/2/2026 has been placed before the court by the petitions counsel to petition, did not be stalled. However, the chairman of the said committee, namely the district commissioner, Hailakandi, will ensure that fund allocation should be appropriately made so as to include any such development works in respect of ward number 3, 7, and 8, if the same are adopted in the meeting directed to be held by the Gaon Sabha. The entire exercise will be completed within a period of 2 weeks. Sorry, 3 weeks, 15 days notice, then 1 more week. From the date of receipt of a certified copy of this order, parties are permitted to place certified copies of the certified copy of this order before the authority is concerned.
Listener, sir. Listener, sir, will have to be certified copy.
No, I'm saying parties, you can also produce because it's a question of developmental work. So
Meeting was supposed to hold today, no?
today,
It can be stalled or it will go on, my lord.
it will go on, but whatever decision they take,
Subject to.
that will not curtail the implementation of the development projects, which may be taken up
If found necessary.
subject to the such meeting directed to be held. Right?
Lordship, just a correction that EC is not the president of the thing. Lordship, it's
Chairperson.
Is the chairperson.
he is not the chairperson.
Then-
EC is a permanent invitee. The chairperson is
President of
Zilla Parishad.
No. District Planning Committee, who is the?
The president of the Zilla Parishad.
Oh, okay.
That, my lord, it will not be disseminated.
President of the Zilla.
President of the Zilla Parishad.
3-5.
But there is no representation before them.
And he is
Cannot
not a
line
party
out
also.
that separate representation. Therefore, the authorities are directed to carry out. In addition thereto, since the president of the Zilla Parishad is the chairman
Yes.
of the District
Okay.
Planning Committee,
May I suggest one thing?
this direction will also be issued. Similar directions are also issued. The president, Zilla Parishad, notwithstanding no representation has been addressed to him. Yes.
Lordship can direct the CEO to place this order before the president. Because president is not a party here. Lordship can direct CEO. madam.
We are directing all the respondents.
Yes.
You will ensure, therefore, we said these orders should be placed by both the parties.
Right.
Disposed.
Obliged to Lordship.
I'll-
So I'm expecting him to inform. We're also ready. Obliged to
Don't
Lordship.
expect only them to inform.
Yeah, we will also do the
Some of
meeting. Yes, your
got an
Lordship.
order.
Yes, your Lordship.
I'll-
Obliged.
Man, form matter delay with you. In the matter of the material. Huh? People make the deal pay to be. Yes. For the judgment. You are appearing in the matter.
Yes.
This is the matter where a policy decision was taken.
In 2013, a cabinet decision was there. They are claiming their right in terms of that cabinet decision of 2013. My stand is that although a cabinet decision was taken, that decision was never implemented. In fact, in subsequent,
Subsequently, a new act has come in.
yes. So initially in 2021 and thereafter in 2025. Now the prevailing act is to 2025. Therein, Lordship, is that it will apply only for the working employees, Lordship. I mean, not for the retired employees. Whereas the petitioner is retired even prior to the filing of the
What is the actual?
copy is there, Lordship. Assam Municipal Employees Provincialization Act 2025. Lordship, two provisions important, Lordship. One is 3(1) small Roman 1. 3(1) small Roman 1. Lordship, kindly see the language there.
1 minute. Assam Municipal Employees Provincialization Bill.
Provincialization Act 2025, Lordship. That bill was submitted just for the getting what was the object behind enacting that. One act is there.
Yes, yes.
Lordship will say 3(1) small Roman 1.
311.
He or she is an employee of the board recruited on or before 4th September 2013. And next provision is 4(3). Next page, Lordship. 4(3). It states, Lordship, the employees who have employed 60 years of age as on
When did the employees retire?
prior to 2000, prior to filing of the report.
Prior to 2013.
Prior to 13. Prior to 13. What you are asking for is provincialization.
Yes, and the retired benefit, pensionary benefit, they have also not received method,
You are working as what?
current capacity.
Now tell us one thing. By earlier, the GMC employees, they were not entitled to pension.
Lordship, this act, Lordship, applies to municipal boards, not to GMC, Lordship. GMC is a different act, Lordship.
No, they are employees of municipal boards.
Yes.
Different boards.
Yes.
So
This applies to municipal board.
So earlier, they were not entitled to pension.
Even now, they are not entitled to pension.
Then what is the change brought in by the new act?
Their services will be provincial. I mean, their salaries, etc., will be, responsibility for the government, Lordship.
Government. Earlier, it was paid from the funds.
Yes.
And if it is provincialized, they are entitled to pension also.
Prior to 2005, prior to subsequent to 2000, new pension scheme, old pension scheme. But in Panchayats, Lordship, there is no such scheme for pension, Lordship.
So what is the effect of the
Regular salary, Lordship. Lordship, may kindly see the preamble of the act, Lordship. Second page, Lordship. To provide for provincialization of the services of the employees working in municipal boards constituted under the Assam Municipal Act 1956. Preamble. Whereas it is expedient to provide for provincialization of services of the employees of the municipal board constituted under the Assam Municipal Act 1956 for its improvement and management and to control activities of the board in the state of Assam and matters concerned connected and incidental therewith. But that act will remain, Lordship. This is an act only for the purpose of provincialization. Other terms and conditions of their service, Lordship, will be regulated by the Municipal Act 1956 itself. On this.
No, they are claiming for provincialization.
They are claiming for provincialization in terms of that cabinet decision of
Cabinet decision.
2013. My submission will be, Lordship, that was never notified. I mean, it was never implemented. Subsequently, Lordship, another provincialization act came, Lordship, in 2021, and that was also repealed subsequently by enacting this particular enactment of 2025. So, and one judgment also I placed, Lordship. Lordship, cabinet decision without notification, Lordship, if it is not notified, merely on the basis of the cabinet decision, no right can be claimed.
What is the judgment?
I think this is Gauhati High Court judgment, Lordship, passed in WPC number 378/2024.
1 minute. WPC.
WPC number 3782/2024. This is Prabhat Chandra Kolita versus State of Assam.
Coordinate bench.
Yes, Lordship, WPC. Paragraph 13, Lordship. Paragraph 13, Lordship.
Hmm.
14. In the case of JP Bansal versus State of Rajasthan reported in 2003 5 SCC 134, the Supreme Court has held that the Constitution required that action must be taken by the authority concerned in the name of the governor under Article 166 of the Constitution. Unless the above formality is observed, a cabinet decision cannot be regarded as the action of the state. It further held that the Council of Ministers are advisors, and as the head of the state, the governor is to act with the aid and advice of the Council of Ministers. Therefore, till the advice is accepted by the governor, views of the Council of Ministers do not get crystallized into an action of the state. But basically, this is the principle, Lordship, I'm relying on. Paragraph 15 was the issue, Lordship, in that case, Lordship.
Hmm.
There was a decision to raise the age of retirement up to 65 years, but that was never, I mean, no order was issued to give effect to that decision. The court said it cannot be directed to be implemented now. Paragraph 15.
One. But Mr. H. Rahman, City Council, assisted by Mr.
Yes, Amit.
S. Ahmed. From the petitioners and Mr. P. Naik, K. Naik. Council
P9.
P9, sorry, P9, additional AG appearing for the state, and Mr. S. Dotto for the. Appearing in the additional. Sorry. The this between the parties have arisen with regard to the claim of the petitioners who were employees of the various municipal boards across the state. Only one.
One municipal board, but the engagements were different, Lord. Post were different.
Which municipal board? Tezpur Municipal Board. They were working as the petitioners were initially appointed by various municipal boards within the state of Assam, in the districts of Dorat, Morigaon, Tinsukia, Sibsagar, Nagaon, North Lakhimpur, Borpeta, Tezpur, Golaghat, etc. Their initial appointments were made by the respective municipal boards, and their salaries were paid from the funds of the boards, and as such, their salaries were not fixed like the other government employees. Stop. According to the petitioners, their service conditions were governed by the same rules and regulations of the state government, and as such, the petitioners have superannuated from their services on attaining the age of 60 years. The petitioners claim that since their conditions of service are governed by the rules and regulations of the state government, on attaining superannuation, they are also entitled to be paid their pension. It is the claim of the petitioners that since their salaries were paid from the funds of the municipal boards, due to paucity of funds, the salaries of the petitioners could not be paid for the years 2008 to 2012. And subsequently, the entire amount was sanctioned. Entire amount towards salaries was finally granted by the state of Assam for payment of salaries from 2008 to 2012. The petitioners submit that having ventilated their grievances before the authorities, the departments finally, the government in various departments in the government finally placed a cabinet memorandum before the state cabinet on 4th of September 2013. By the same cabinet memorandum. Is it here, cabinet memorandum,
Yes, Lordship.
page number?
Page number 100, Lordship. Annex B.
The cabinet approved the recommendation of the committee of the group of ministers on the final report and supplementary report for the fourth Assam State Finance Commission on the staffing pattern of the local bodies like the municipal boards and provincialization of the services of the employees. Stop. The learned senior counsel for the petitioner has strenuously urged that the highest authority in the state, namely the cabinet, has taken a policy decision for grant of status of provincialization to the petitioners and for release of pensionary benefits. However, for reasons best known to the government, this decision could not be came to be implemented and no specific orders were passed by the administrative department notifying the decision of the government and implementation of the same. So, the petitioners continue to represent before the authorities concerned. However, since their grievances were not redressed, we have approached this court by filing the petition, seeking direction to the respondents to implement the cabinet decision dated 4th of September 2013 and to provincialize the services of the petitioners for the benefit of their pension and to take necessary steps for grant of pensionary benefits to all the retired employees of the municipal boards, the town committees within the state of Assam, and also pass appropriate orders as deemed proper. There are the respondents of Mr. Roman has pressed into service the judgments, the following judgments in support of his contentions. Referring to the said judgments, Mr. Roman submits that once a policy decision is taken, it is mandatorily required to be implemented unless the same is revisited and the policy is recalled, stopped. He submits that in spite of several years and successive governments in place, the policy was never recalled. So therefore, as on date, there is a cabinet policy, cabinet decision that the services of the employees of the Assam municipal boards are to be provincialized and they are to be granted pensionary benefit. That notwithstanding, the administrative departments have failed to carry out the policy decision taken by the state. So, the government of the day has also not revisited the policy and have also not taken any steps to ensure that the policy is in. Referring to the said judgments, learned senior counsels, that the 4th, 2023 Assam State Finance Commission on the staffing pattern of the local bodies like the municipal boards and provincialization of the services of the employees like the municipal boards are to be provincialized and implementation of the same. There are the respondents of Mr. Roman has pressed into service the judgments in support of his contentions. Referring to the said judgments, that the state being a welfare state, such decisions taken by the state in the interest of its citizenry are required to be implemented in right earnest. And the appropriate departments are were required to be suitably directed by the state government to carry out the state policy by issuance of appropriate notifications and gazettes. There are additional AG for the state has strenuously has strongly objected to the contention east. Comes that at the relevant point in time, because the state felt that some decisions were required to be taken and has accordingly adopted a policy decision. This policy decision, for reasons best known to the government, however, could not be implemented. And at this stage, the implementation of the same is not called for, inasmuch as by subsequent statute, namely the Assam Municipal Employees within bracket Provincialization Act 2025 was enacted, and it was gazette notified on 16th of June 2025. Referring to the same statute, the learned additional AG submits that the statute is very clear in respect of the applicability of the provisions of the statute on the employees, inasmuch as per clause 3, as per section 3(1) within bracket Roman 1, it is clearly prescribed that the provincialization of the services of the employees of the boards will be in respect of an employee who was recruited on or before 4th September 2013. Where is that relevant clause you pointed out? This one or some?
This is 4.3.
4.3. Sorry, not 4.1. 4.3. 4.3, 4.3. Not 4.1, not 3.1. 4.3 provides that 4.3, referring to 4.3, provides that employees who completed 60 years of age as on the date of coming into force of this act shall be deemed to be retired with effect from that date, and they shall have no claim whatsoever from the state government as regards their pay, allowances, benefits for services rendered by them before the date of provincialization. He therefore submits that the claims made by the petitioners do not merit consideration, inasmuch as a statute brought in by the Act and brought in by the legislature of the state is a reflection of the policy decision taken by the state, and which culminates into a law enacted by the state legislature. This law enacted by the state legislature will override any other policy decision taken which was not implemented as per procedure prescribed. So therefore, the claim of benefits by the petitioners under the cabinet decision do not merit consideration. the petition. In join the senior counsel some that the only relief the petitioners are claiming are inclusion of their claims for payment of pensionary benefits. And this could well have been included in the subsequent act brought out, namely the Assam Municipal Employees Provincialization Act 2025. Since there is already an earlier decision taken by the states in the form of a cabinet memorandum dated so and so. You submitted that the government's decision cannot have conflicting conclusions. So once a decision is taken, once a policy decision is taken, then the decision must be reflected in subsequent actions of the government. And such subsequent actions must be in tune with the earlier policy decision. However, the present, however, the new statute, namely the Act of 2025, is completely opposed to the cabinet memorandum, which was earlier adopted by the state. Accordingly, submits that it is the policy decision taken by the cabinet memorandum which has to be understood. He therefore submits that in terms of the policy decision adopted in cabinet by memorandum dated so and so, the claims of the petitioners should be accordingly considered by making suitable modifications in Act of 2020. Therefore submits that the writ petition grievances raised be allowed and suitable directions be. Counsel for the parties have been heard, pleadings available on the careful. It's seen that at a given point in time, the government of the day, upon considering the claims raised by petitioners, have taken a policy decision in which policy decision in the form of a cabinet memorandum dated so and so. There is equally no dispute that this cabinet memorandum did not come to be implemented, and there is no order passed by any administrative department bringing out notifications or office memorandums implementing the decisions taken by the cabinet. In the meantime, the act of so and so came to be enacted by the states, where there is a clear provision under Section 4 that employees who had attained the age of 60 years on the date of coming into force of that shall be deemed retired and will have no claim. In the act, we've said section is extracted below. But having noticed the arguments are addressed before the court and the claims of the parties question before the court is whether cabinet decision in itself can be considered to be a reflection of the policy decision which must be and or needs to be implemented. And any subsequent decision or action, decision taken or action undertaken by the state cannot be or ought not to be in conflict with the earlier decision taken by the state by way of the cabinet memorandum. In this context, it is necessary to refer to the celebrated judgment of the apex court rendered in Bachittar Singh, quoted in AR 1963, Supreme Court 395. The apex court, if we say judgment, was also confronted with this question as to whether, as to the effect of a cabinet decision undertaken by states. The apex court held that in the scheme of the Constitution of India, a minister or N within bracket S are not more than advisors under the head of the state. So the head of the state is the governor under Article 164. Constitution এমন কিছু Constitution দিলে হলো না। The 153. The advisors to the state, namely the ministers, who are elected representatives of the citizens, are to deliberate on various public issues and thereafter take a decision in the form of a cabinet memorandum. So, this decision, this cabinet memorandum is not a decision taken by the state, but will have to be considered to be an advice suggested by the representative of the elected representatives of the state, to be forwarded to the head of the state for its due acceptance and then or approval. Until and unless such advisory of the Council of Ministers in the form of a cabinet decision accepted by the head of the state, namely the governor of the state, it does not become a decision of the state. Stop. The advisory of the Council of Ministers in the form of a cabinet memorandum would still be an opinion expressed, which will become a decision of the state only upon the acceptance by the governor of the state. Subsequent judgments of the apex court relied thereupon would also be relevant for your reference. In J.P. Bansal versus State of Rajasthan, reported in 2003-5 SCC 134. the apex court held that the Constitution requires the action taken by the authority concerned, the name of the governor, must be under Article 166 of the Constitution. Unless the above formality is observed, cabinet decision cannot be regarded as an action of the state. The apex court reiterated that the Council of Ministers are advisors, and the head of the state, namely the governor, is to act, albeit with the aid and advice of the Council of Ministers. Therefore, till such an advice is accepted by the head of the state, namely the governor, the views, the advisories of the Council of Ministers in the form of a cabinet decision do not get crystallized into a decision and of vigor and action state. These two decisions also find reference in a judgment rendered by a coordinate bench in WPC 3782 of 2024. Dr. Prohibitions versus State of Assam. And similar was dispelled by a coordinate bench relying upon the same judgments. The judgments referred to by the petitioner context are in respect of decisions which were taken by the state. Conflict of decisions taken by the state. So, certain decisions earlier were subsequently sought to be altered by taking a completely by making a complete vote face, OLTEFAC, which the apex court in the facts of the case, facts and circumstances of the held was not permissible. Here, the decision of the state was reflected by appropriate notifications and office memorandum. In the facts of the present case, no such office memorandum or notification was issued pursuant to the cabinet decision taken by the state. So, such decision could not have been issued in view of the constitutional framework where these advisories and the form of cabinet memorandums are to be put up for approval before the head of the state, namely the governor of the state. Is only upon due acceptance by the governor of the state, views and opinions of the cabinet are considered to be accepted and given a stamp of approval. Subsequent thereto, consequential notifications of office memorandum, etc., would have been issued. In the facts of the present case, no such steps where consequential steps were taken pursuant to the decision of the cabinet decision taken by state. So therefore, cannot be said that a cabinet decision taken by the state will reflect a policy decision taken by the state in the constitutional framework, and which decision mandatorily is required to be implemented till such time the same is repealed or revoked or recalled. And in view of the above discussions, the court does not find any merit in the writ petition, and the submissions urged. Writ petition, therefore, being devoid of merit, stand dismissed. However, no order is to post. The petitioners are aggrieved by any of the clauses of the Act of 2025, Needless to say, it is open for them to challenge the constitutional rights of the say elect, which are the appropriate vote. What order are you, where you, what are you aggrieved by? What, which orders?
Page 88.
88.
Thereafter, I submitted representation. They issued further in rejection order.
88.
Page 88. Before this, Lordship, I first came to know about the refixation and downgrading of pay by order at page
Okay,
83.
Mr. Deka. We'll have to remand it back to the authorities to revisit this. Other than that, sitting here and trying to work out what
It will be difficult, madam.
teams he wants, what benefit he wants, will not be possible.
It will not be possible.
We will direct them.
I have a small submission, Lord.
Oh,
I was granted this benefit and I was continued with this benefit till the date of my retirement, Lord.
now it has been withdrawn.
On the last month of my service, they have withdrawn it.
Huh.
They have taken it out. Now, if they do it, then it has to be based on some records.
So that is why we want to remand it back.
Let them pass the speaking
Considering
order.
your submissions that you were promoted, you were appointed. Vis-a-vis the claim of the respondents that you were promoted.
But now they have passed not only one, but four speaking orders. 4 orders they have already passed. Lot of water has already flown, Lordship. So now they will pass another order like the 4 orders which they have already passed. And people exercise. Because already they have issued 4 orders, section orders. At
What
page-
is the ground on which this thing is withdrawn? The headphones already.
Yes. By reading the all impugn orders, I have understood that they have taken away 2 benefits. First, Lordship, the financial upgradation benefit, which was earlier granted to me on 1/1/2007.
On what ground?
On the ground that I am entitled to, as per the financial upgradation benefit, I am entitled to only 2 financial upgradation.
Why?
The scheme is such that, Lordship, scheme provides that a person on completion of 10 years of service, he gets the first financial upgradation. Then on completion of 15 years, he
So-
gets the second.
So the department was of the view that you having been given a promotion,
Promotion.
you had got your benefit, so you're not entitled to the
Yes.
upgradation.
Yes. That is their plea.
So on the basis of these documents, how is it possible now to conclusively say that you are appointed, not promoted?
Yes. Lordship will see the order for a moment, Lordship. Page
Number?
30 order.
30.
30 order. Order of my appointment to the post of typist. The order is very clear, Lordship. I'm reading the order. Subject to satisfactory police verification report on character and antecedents and submission of medical fitness certificate, the marginally noted persons are appointed temporarily. Word is appointed, and until further orders as typist in the office of chairman. These are the persons, out of which I have already submitted. 3 are from the open market, they participated in the fresh examination, and 2 are from the department, they are departmental candidates, they participate fresh. Then last paragraph, Lordship will see, last paragraph.
The appointment is purely temporary. Purely temporarily, and their service is liable to be terminated at any time without notice and without assigning any reason thereof. At two places of the order, they have clearly and without any ambiguity used the term appointment, appointed. They have nowhere used the word promotion from a particular post to another post.
So how many increments were taken away?
Increments are granted every year, annual increment which is due on July.
Hmm.
Now, this has no connection with increment.
No. Insofar as the claim, your claim is concerned, according to you, you are getting certain benefits,
Financial upgradation.
upgradation, which was taken away.
Yes.
How many financial upgradations were taken away?
I was granted on 1/1/2007.
One,
Counting
which is after 10 years.
after 10 years.
Then that was taken away
That was taken up
on the basis of this order.
on the basis of this order.
That's
And
all.
This is one aspect.
Ah.
Then another aspect is the promotional increment that I'll come later also. It will create confusion. Now, this order, this fresh appointment is preceded by a selection.
No, that we have understood. Besides this increment in
Upgradation.
besides the increment for the, this is like MSCP.
MSCP,
MSCP in this
central government, state government.
increment. What else was taken away?
3 promotional increments.
Why? Because
They
you were
say-
appointed.
No, they say, along with those promotions, I do not assume higher duties and responsibilities.
Which is under some
FR, that is connected to FR.
FR,
FR.
which is not there, is it, Mr. Dekha?
It is there, FR 22.
It is there, FR.
But prior to the FR, Lordship, my accrues, Lordship, in my humble submission, Lordship, before going to the FR, my right accrues under the revision of pay rules, Lordship. However, I'm entitled under the FR also.
Where are the impugned letters? Page numbers?
88, then 90,
No, 8, 9, 21 is that page?
88,
88. Then 31, 22,
then 90,
90. Then
91,
91,
and 93.
93. This 91 of 4 financial upgradations are in respect of promotions only? Or it
No,
includes?
no. That is first aspect. First aspect.
Huh?
It is in aspect of the appointment and promotion. First aspect.
No.
This promotional increment is the second aspect, Lordship.
Okay.
FR, ROP rules.
No,
is the
but
sec-
you are allowed 4 financial upgradation benefits. Under what provision were you allowed?
No, I was not allowed 4. I was allowed 1. That will, Lordship will be clear at page 88. 88 is clear.
No, but this letter says you are allowed 4.
Yes, this is a subsequent letter. This is not actually clear. Page 88 will make it clear, Lordship. 88.
88 we have seen.
I will go to 91 also, but 88 makes it clear, Lordship.
Hmm.
What they want to say. After checking, I'm reading para 1, Lord.
Hmm.
After checking time to time pay fixation of the incumbent, it is observed that the incumbent was promoted to the post of senior peon
Hmm.
on 1/7/1987, allowing 1 promotional increment, which is irregular, dated so and so. Again, the incumbent was promoted to the post of typist in the office of chairman, wide order number so and so, dated so and so. Moreover, incumbent was allowed scale benefit on 1/4/97 in the scale of so and so, and financial upgradation benefit on 1/1/2007 on completion of 25 years of service. This is incumbent That is the incumbent was around 4 financial upgrades.
1 minute. You have two compartments,
2 compartments
right? One is that according to you, you were appointed,
appointed.
not promoted. So since you are appointed, and there was no promotion till whatever period, you are entitled to one upgradation,
Upgradation.
right? Which they gave it to you initially.
Yes.
Subsequently, you were promoted to some other post. no?
Yes. Yes.
Some other post.
Yes.
What post was that?
Junior assistant, senior assistant, and superintendent. 3 promotions I had.
3 promotions. In these promotions, there is some promotional increment,
Yes.
which now they have said that because you have not assumed higher responsibilities have been taken away.
Yes.
And this is as per FR 22.
22. The requirement of assumption of higher duty responsibilities is under FR 22(1)(a)(1).
22
22
A1.
1(a)(1).
1A1.
I have gone through that book, Lordship. It is perhaps marked, flagged in orange, Lordship.
Flagged in orange. Flagged in orange is 21.
No, below 21, Lordship will see. Below 21, it is written 22.
The earlier 22. 22 was substituted in 1989.
1992. Earlier it was 22A-B-C. Later it became 22(1)(a). Actually, Lordship,
Hmm.
we need not even go to the FR, Lordship. This is prescribed under the revision of pay rules also of the department.
But we want to understand why
Yes,
FR 22 was referred.
FR
They also take it off you. The FR 22 Z2 as it doesn't reflect.
page 62, Lordship. 62. Sixty-two.
62.
Page 62.
62 is 21.
Below 21, Lordship.
Yeah. So they were relying on 22(2).
According to those who do not assume higher duties responsibilities,
That's what 22(2).
22.
Yes, Mr. Deka. Firstly, it appears to be an appointment.
Coming back to that matter,
Hmm.
I cannot dispute the proposition that the order says it is appointment. But if your lordship sees the copies marked at page, I'm looking at the original at page 33 and
At the
34.
time you were appointed, how many years did you put in?
Lordship,
At the time
8 years.
you were appointed,
yes.
how many years did you put in
I completed 8 years as peon.
as peon?
Peon.
No, as senior peon, he was promoted on 1787.
1787.
1780, he was appointed as peon.
Peon.
1787, he was promoted as senior peon.
Senior peon.
After how many years?
7.
7.
7 years. So how are you entitled to the increment?
No, this
You
is
got
not
your
connected to
promotion.
increment.
Uh,
Taking 10 years from fresh appointment as typist in 88,
Hmm.
I got the financial upgradation benefit in 2007.
No. Your financial upgradation is subject to the fact that you were never promoted.
No, my fresh
I don't
appointment,
know, subject to, if I recollect in the MSCP or ACPS scheme, if you are not given the promotion in 10 years, then you are
Yes.
given a benefit.
my
Same,
submission is,
same scheme is here also, my lord, at page 116.
yes, my submission is that since it is my fresh appointment,
Hmm.
everything will start afresh from my fresh appointment as typist. From 88, it is to be counted. From 88, it is counted 10 years, I did not get any
And
promotion.
how many years of service is counted for purposes of promotion
10
from
years,
accountant?
10. 10 plus 15.
No, what I'm saying is the
Promotion is a pattern.
earlier years that you have put in, was it counted towards pension?
Pension, it is not required, Lordship. I will get the entry pay of the post of typist. That past service, it is not required, Lordship.
These things are not available here for some reason. You see, he joined as a peon, then got promoted as a senior peon. Then in response to some advertisement he applied, he was appointed as a typist. Then he works, gets an upgradation, then subsequent promotion, and he retires. Now, what is the total length of service? Is it counted from accountant or is it counted from peon?
So we have counted from the post of peon, but if his case is considered, then he has to be counted from typist.
Yes, it may be counted because I have completed much more than 30 years.
But that will require recalculation of the pension which has been granted to you.
No, Lordship, I was granted the entry pay of the post of typist.
The council. For your pensionary benefits, the first date of service is to be taken into account. First service.
That is only for calculate the qualifying service, Lordship. Only
That's right. Qualifying service, but your pension will be relatable to the pay that you had earned earlier, which will have an effect.
It is having no effect, Lordship. It is having no effect because when I was freshly appointed as typist, it was in a particular pay scale without carrying any pay protection or further benefit from the earlier post. Because typist has a
That
particular.
is what we wanted to see. How have they treated the service of your services you have rendered as peon initially?
Lordship may record it. I am ready to give up or not to
No.
count my past service.
We are not inviting you or asking you to give up. We want to see how they have treated. Supposing they have treated your services from the date of your entry as a peon, salaries or whatever you have got. The calculation will go accordingly.
In my humble submission, no, Lordship, because when I was appointed as a typist, I was granted the entry pay of typist without any previous benefit, Lordship. Previous benefit, I did not carry any previous benefit. It is a particular
So
pay.
if you calculated that,
I cannot submit beyond what is there in page 93, my lord.
Lordship will for a moment see
Not 93,
page 30.
from 88.
Page 30, Lordship will kindly see. What I got when I was appointed as typist. Page 30, Lordship. I was granted a particular scale of pay. That is of the post of typist. Page 30, Lordship will see. AACB, Narengi, Gauhati, just below the names, page 30. AACB, Narengi, Gauhati, in the scale of pay of rupees 530, so and so 840.
we have understood your matter, but you see what happens is subsequently if they come to know that your service, because according to you, you have gone into a different service by fresh appointment. If their calculation is from the date of peon, then they'll have to recalculate.
there is pay of the peon cannot be at any circumstances more than this particular pay scale that is of the typist. It will at any circumstance be of a lower category, lower amount. He was merely a peon, lordship, and he became a typist. So it all started with 5300-840 pay scale from 1988 when he became a typist.
Not corresponding with page 88.
So far as the promotional increments are concerned, I think that you'll have to give it to him. How can you say there's no holding of higher responsibility? He's been promoted.
Not the increments, my lord,
Huh.
the upgradation.
No, he's talking about the
No,
increment.
increments have not
No.
been taken away.
This is financial upgradation
This
we are
financial
talking
upgrade.
about.
Increments, you're
Increments is getting-
Increments is promotional at the time of my promotion to junior assistant, senior assistant.
what was deducted from your pension only financial upgradation.
Financial upgradation as on 1/1/2007. This is the first aspect which was taken away. Second is the promotional increments. Three
That's what I'm
promotional
saying.
increments.
Only the promotional increment,
That's
the
right.
increments which he has received at the time of promotion, not the subsequent increments.
No, correct. But that was taken away on the ground that he was not
Okay.
holding higher
Yes,
responsibility.
yes.
Which, on what basis are you doing it?
Because it is the post from typist, I mean senior peon to typist, so it is not carrying a responsibility of higher degree, man.
Okay, the promotional increments from is deducted was in respect of senior peon to typist, not from typist to LDA.
Not from typist to LDA.
So from typist to LDA, then LDA to UDA, and UDA to superintendent.
This complete.
Page 90 makes it clear. Their statement takes us to a document at page 95.
Let us do like this. You give your gist, give the dates, give it to Mr. Deka. If both of you agree, submit to us, we'll close it. Not today, Tuesday or Thursday, whatever date. If you agree. If from your submissions, it is clear that your service rendered as a peon promoted to senior peon is in a different compartment. Subsequently, your services started afresh on the basis of being appointed as an accountant. From there, for 10 years, you continue, no promotion was granted. Therefore, you are entitled to an increment,
Financial upgradation.
financial upgradation. That we accept. Subsequently, when you got promotion in
Yes,
the
sir.
next phase, you got only one financial upgradation or two?
I got one financial which was taken away.
Only
Yes,
one, huh?
one.
Only one. So in the second compartment, which is in the second 10 years, you got your promotions as LDA, UDA, whatever,
Superintendent.
superintendent. There, certain promotional increments were granted to you.
Yes,
There, in those
Yes,
promotion,
yes.
which was again taken away. So, Mr. Deka, according to your submission, is that the promotional increments from peon to senior peon was taken away.
No, madam. Even from the post ups to the senior assistant has been taken away.
Then that is to be allowed.
Peon to senior peon, I'm not concerned.
If his submissions subject to what falls from you, I mean, what you have to say, his case is that his service comprises of two compartments.
Yes.
Initially peon, promoted to senior peon. While he was there, some advertisement was there, he applied, he got appointed.
Yes.
So that earlier period is gone. There is no pay protection, nothing. This is a fresh start. He goes on for 10 years, no promotion. He's entitled to financial upgradation, he gets one. After 10 years, he gets 2-3 promotions. On each of these promotions, he's given a promotional
Upgradation. Increment.
increment, which was entitled to him in his pension, etc. Subsequently, you seek to take away by saying that he was not holding more responsibility.
Under FR50.
That on the face of it doesn't appear to be correct because he was promoted.
But it is not, I had, on the last occasion, I had placed a judgment, my lord, relying on particular paragraph. It is not automatic, my lord. That is my submission.
Is Bhagavan Shukla.
That I relied, lordship, for refixation,
Syed Abdul
no
Qadir.
notice.
Syed Abdul Qadir.
2009 3 SCC 475. Yeah.
2009.
3 SCC
Mhm.
475. Para 37 onwards, 37 quotes the earlier FR 22. Then the 38 is the amended. Then 39, 40, and 41, Melo. More particularly 41. May I read, Melo?
Wait for a moment. এটা এই ওয়াইফাই তো আপডেট করবো দিবস রাউটার লাগে বলুন হ্যাঁ হ্যাঁ আপডেট বলবো What was the citation? 93.
2009, 3 SCC 475.
2009. 3 SCC.
3 SCC 475.
Yes. Paragraph.
From 38, the 37, the FR 22 is quoted. 38 is the amended FR 22. Then from 39 onwards. Rule 22(1)(a)(1) provides that when a government servant is promoted or appointed to a higher post, and the higher post is promoted to carry his duties and responsibilities of greater importance than those attaching to the post held by him, his initial pay in the timescale of the highest post shall be fixed at the stage next above the notional pay arrived at by increasing his pay in respect of the lower post held by him regularly by an increment at the stage at which such pay has accrued, or rupees 100 only, whichever is more. 40. According to FR 22(1)(a)(2, the benefit of an additional increment which is available to the government servant under FR 22(a)(1) would not be available to the government servant if the higher post is promoted or appointed to does not carry duties and responsibilities of greater importance than those attaching to the post held by him. Then 41 makes it clear. Even according to FR 22C, the additional increment was to be granted only in cases where the incumbent on promotion or appointment to a higher post has to discharge the duties and responsibilities of greater importance. Therefore, in cases where on promotion or appointment to the higher post, no duties and responsibilities of greater importance than those being discharged in the post held by the incumbent regularly prior to the promotion were to be discharged by the government servant, the pay fixation formula is provided for under FR 22(a)(2, according to which benefit of additional increment is not to be extended at the time of fixation of the pay on promotion. So, it includes both promotion as well as appointment. So, even if his appointment is, our case, it's a promotion to the post of typist is a promotion. I mean, is a fresh appointment. Then also FR 22(a)(1) will come. A2, sorry, man. Then 43 is on the facts of that case, man. The admitted position in the case on hand is that the post of assistant teachers on promotion to the higher selection grade does not carry any duties and responsibilities of greater importance than those attached to the post held by them regularly prior date. So that has
But
to be,
it is on a selection grade.
no, that is on the facts of the case.
That's
So
right.
here that,
You'll have to give us findings to say that his promotion did not carry higher responsibilities.
that is why, my lord, there has to be a fresh evaluation, my lord, of what are the duties of a typist. What were the duties of the,
Until you do so, cannot take away.
May I submit it?
Hmm.
AACB has a separate set of rules. These are called the Revision of Pay Rules 2010 and 2017. 2010 rules, Lordship will see at page 39. We need not even go to the FR. Page 39, Lordship will see. Revision of Pay Rules 2010. Page 39.
Hmm.
Revision of Pay Rules 2010.
Hmm.
My right accrues for a promotional increment under these rules. My right accrues for promotional increment accrues under these rules. Lordship will see para 8 at page 44. Para 10 at page 45. Para 10 at page 45 of these rules.
Yes.
Fixation of pay on promotion on or after first day of January 2006. Lord, directly Lordship may come to note 1, page 46. Note 1. This is my case, note 1. In case the employee opts to get his pay fixed from his/her date of next increment, then on the date of promotion, pay in the pay band shall continue to be unchanged, but grade pay of the higher post shall be granted. Further refixation shall be done on the date of his next increment, that is for July. On that date, such an employee shall be, this is important, Lordship. On that day, such an employee shall be granted 2 increments, one annual increment and the second on account of promotion. So these are the rules of AACB. Rules of AACB. Now, Lordship will kindly come to page 90. This is their impugn order, second impugn order, which directs us to another office memorandum, Lordship. For a moment, I am reading para 1. After checking time to time, it is observed that pay at the time of promotion to the post senior assistant is fixed with an increment which is irregular as per letter 18/7/2003. Now, 18/7/2003 is at page 95. This is in respect of, your Lordship had rightly pointed out, in respect of selection grade and senior grade post. Selection grade and senior grade post, page 95. As per this OM, they do not say as per FR. As per this OM, I am not entitled. I am reading this OM, Lordship.
We need not. We have understood that.
This is in respect of selection grade, senior grade, which are actually time-bound promotions, time-bound promotions for higher level posts without connection to vacancies. With a fixed
Not
period.
higher level, same post. Same post, you are given
Same
a
post.
grade.
Same post, but
On
what
the expiry or
Yes.
influx of the time,
Time.
getting more pay.
More.
But the responsibilities remain the
the
same.
responsibilities remain the same.
Therefore, you are not entitled to a increment.
Then
That is
I
what-
have even shown, Lordship, I have even shown what duties I perform.
page 95 does not say selection grade, my lord.
Does.
Does.
Second para, third para, only. Second para,
Second para,
third para.
third para. And even next page, second para, Lordship.
As in the amended provision, an employee appointed to a post not involving duties and responsibilities of greater importance, as in the case of selection grade. So when you reach a selection grade, you are discharging duties of higher responsibilities, my lord. It does not say that the application is, the OM is applicable for selection grade, my lord.
No,
No, no.
right.
That statement is contradictory to page 96, second para.
Hmm.
It is top for selection grade and senior grade. They will not get.
Does not say so, my lord. Let us read again. As per the amended provision, an employee appointed to a post not involving duties and responsibilities of greater importance, as in the case of selection grade, senior grade. So therefore, when you reach a senior grade, selection grade, you are discharging this, duties of higher responsibilities.
No,
No.
it's the other way around.
Page 96, Lordship.
See, selection grade is nothing but a time-bound
Yes,
increase in your pay, but your responsibilities remain the same. This is like promotion in situ.
Yes.
You are in the same post, but with higher
Higher
pay.
higher pay.
But ordinarily, this perhaps because the rules say so, or because there was no, it's not in situ, but this is probably because the rules say so. But if you are promoted to a completely new, different post, then it is deemed that you are assuming high responsibilities.
That come
From
automatically,
a
madam.
teacher to a senior teacher or something like that.
Here it's a case of junior assistant to a senior assistant.
Exactly.
Will you
That-
automatically discharge these responsibilities of
That's
higher?
what, I don't know your rule, what your rules say. Otherwise, why are you promoting him?
Promotion he will get, my lord. Promotion it is,
So the concept of promotion is to give high responsibilities,
my lord,
higher pay, higher benefits.
reading that judgment of the apex court, my lord, as well as FR20, it is not automatic, my lord.
This judgment of the apex court is with regard to selection grade. Therefore,
No,
it is not automatic.
with utmost respect, my lord, it does not say so.
It does.
It is on the fact, the facts is paragraph 43 is on facts, my lord.
Yes, yes.
But 41 says on FR22, because then FR22 is left redundant, my lord.
No. FR22, you may use it
Yes.
for cases even beyond selection grade. But where the rider is that you must be convinced that there is no high responsibility.
Exactly.
Where is that confusion?
So for example, an LDA who is promoted to UDA in the same office, he may be discharging the same duties, my lord, same sort of duties.
We don't know, not maybe. You have to give reasons. You have
That
to
is what-
say that just hypothetically
Yes.
that uh, uh, what is this LDA? He's in charge of these registers, 5 registers. Once you become UDA, you are in charge of 10 registers, but essentially you are doing
The same work.
the same work. So therefore, no promotion.
No.
That finding has to be there.
Not promotion, my lord, no,
No increment.
no increment as to FR22.
That finding has to be there before you implement this order, before you take recourse to 22.
That finding is not there, my lord.
Therefore,
So there has to be an analysis there, whether the duties are similar or not.
we have not done it, so what can be done? If it is there in your records, you go and get it.
No, it
If
is not there,
it's
my lord.
not there, then
it
that's
is
the
not
end
there.
of it. They have misread 42, 22 perhaps.
Lordship, in my humble capacity, I have attempted to show my duties. So duties of LDA, UDA and superintendent. At page 130,
We are not there. We don't even want to go and see what duties we are doing. We are saying that this is a promotion. It is prescribed under the rules. The rules must be having a cadre strength. These posts may be in the same cadre, or I mean, same grade or different grade, we don't know, but different posts. And these promotions must be in terms of the rules, which will say that these are the qualifying, that number of years are necessary for consideration for promotion. So this is not an in situ promotion or higher grade. Yes, Mr. Dega, I think time to wind up. Finally.
Give it to your lordship, my lord, because beyond what is there in the
What
record,
can be done now?
beyond that, I cannot argue, my lord.
Third, Mr. Dr. Sharma, so learned counsel for the petitioner. You are entitled to correct the names, correct the judge, there's no problem. We get confused sometimes with names. As also Mr. M. Dekar, with respondents, the petitioner served in the ACB as it then was, and subsequently renamed as a PTCL. In various capacities and ultimately superannuated as superintendent
superintendent,
on
30/09/21.
30/09/21. Petitioner was thereafter given pensionary benefits and he was drawing his pension. Subsequently, the petitioner pension was sought to be some increments received by the petitioner during his service was sought to be curtailed or withdrawn by the respondents.
Actually, it was on the last month of his service.
Okay. Petitioner was working, subsequently retired, superannuated. In the last month of his service prior to superannuation, certain benefits which was received by the petitioner by way of increments
And financial
obligation was withdrawn or curtailed, was sought to be withdrawn or curtailed by the respondent authorities. Stop. By communication, tell us by which communication it was taken away.
First order is at 17/9/21. I came to know.
Page.
Page 83. I came to know. Then I approached the department
This is while you were in service.
while I am in service. September 21, last
The
month.
petitioner came to be aware of this curtailment or withdrawal of the increments upon receiving his salary statement, wherein is from the details of the calculation, he could make out that there is a difference between the salary which he has received for that month, or between the salary received as received earlier for the earlier periods of time. Subsequently, he approached the authorities, and then
They gave me letter at page 83.
88.
88.
He was served with a communication dated 8/9/2021, Annexure 14, whereby the authorities had recorded that the petitioner petitioner was promoted to the post of senior peon from the post of peon, and subsequently promoted to the post of typist in the office of the chairman. Therefore, the financial upgradation benefits which was granted to the petitioner on completion of 25 years of service ought not to have been conferred on him. So then
I submitted representation. Then they gave me letter at 90.
petitioner submitted his representation, to which the respondents maintain that his promotion, that he was appointed to the post of typist, and subsequently thereafter to the post of junior assistant, senior assistant, and finally superintendent. So the petitioner being aggrieved,
Other orders are there.
tell us which pages.
Then I again submitted representation and they gave letter at page 91.
91.
91. Then again in 93.
So initially at 88.
88, 90.
Then pursuant to which he submitted a representation thereafter by communications dated 90, 91, 93.
93.
Petitioner was informed by the authorities that his financial upgradation benefit was irregular as per the departmental notifications and office memorandums, as he was given a promotion to the higher post of typist from the post of senior peon, and therefore he was not entitled to the financial upgradation benefits. Stop. The subsequent promotional benefits given to the petitioner on being promoted to the post of
Junior assistant, senior assistant, and
Junior-
superintendent.
a junior assistant, a junior assistant, senior assistant, and superintendent was also curtailed on the ground that he did not perform higher responsibilities. Repeated representations did not yield any response. Accordingly, the petitioners approached this. The respondents have contested their case by filing necessary affidavit justifying the claims of the APDCL, maintaining that curtailment of the financial upgradation and benefits was justified in terms of the rules and regulations as well as the several notifications of the department.
May I just point out one clause, my lordship may record as part of my submissions, my lord. Page 117, my lord, why it was considered as part of the as a promotion, my lord. That is in para 6 of my affidavit, I have stated that. The clause is also quoted, my lord, page 117 4D.
1217 4D.
40. For grade 4 employees, the post of LDA cum typist in the HOD offices, meter reader, etc., to which they are appointed as such against departmental reservation on the basis of departmental test shall be treated as promotion post for the purpose of this scheme.
Financial upgradation.
It's a scheme of financial upgradation. And the upgradation he received, my lord, as per the order at page 88, is on completion of 25 years, not 10 years. It's in the middle portion of that page 88 order. Moreover, the incumbent was allowed the scale benefit on so-and-so in the scale of so-and-so and financial upgradation benefit on 1/1/2007 on completion of 25 years of service. So it is his contention and it is 10 years of service.
May I clarify this? Lordship will see page 134. This was not a departmental test. Page 134. That is part of my affidavit in reply. Subject selection test for recruitment as typist. My roll number 21. Please appear in the selection test for appointment as typist. It was not a departmental test. This is the against his first statement. Then
This
page
is conducted by whom?
department.
Then
But it was not a departmental promotional test.
under what sense they're using the. You can't be so rigid about it. Departmental test means a test conducted by the department.
But not for promotion, but for appointment.
Hmm?
But for appointment.
Ah,
So if it is an appointment as per 4D, it shall be treated as a promotion.
provided it is
If it is
against
a departmental
departmental,
test. If it is a departmental test.
departmental reservations.
Departmental test, no?
No. Against departmental reservation on the basis of departmental test.
ACB wants
So
employees.
first there has to be reservation in a sense
In
that
this
you are
sense.
keeping in few posts for departmental candidates.
Because normally, my lord, it will not be a promotion per se because he was promoted to the feeder post 1 year prior thereto. Your lordship sees I had made a chart for myself.
Yes.
He was appointed as peon in 80, then senior peon in 88. So he cannot be promoted to the post of typist unless there is a departmental test. That is my submission, my lord. If it
He
is, a-
says it is not a promotion, it is an,
his case is not a promotion.
he says it is an appointment.
It is a fresh appointment.
Fresh appointment. So
Even
this
going
is-
by the appointment order, his address is shown as the office of the chairman of the
Because I'm easily
APTC.
available in the office.
Just a minute. And there is no
Till the time
medical,
he was appointed, he continued to work.
he
It's not
continued
that
to work.
He had resigned from the,
No, there is no resignation.
there is no resignation.
Difficult,
That normally raises a question that how are you permitted to apply in a
Exactly.
fresh appointment
Exactly.
without the NOC from your
without the
employer?
NOC.
Unless it is a departmental case.
Exactly.
It has examination and indents were sent to employment exchange. And they sent us letter through the department only at page 134. You come and appear in the selection test. Whatever exam it is, it will be conducted by department only.
He will last. The Learned Council has referred to the OM dated 30th December 2006 in respect of financial upgradation scheme to submit that as per clause 4 within bracket small d, it is provided that for grade 4 employees, the post of LDA cum typist / typist in HOD offices / meter readers to which such departmental reservations on the basis of departmental tests were conducted shall be treated as promotion for the purposes of the scheme. So he therefore submits that in view of this particular office memorandum, the engagement of the petitioner pursuant to a selection process as typist was considered to be a promotion and not a fresh appointment. In that view of the matter, since the promotion was already granted to the petitioner, he could not have been entitled for financial upgradation under the OM dated so and so 30/12/2006. The petitioner on Amad Gibo, the petitioner is referred to and relied upon the case of Bhagavan Shukla reported in 1994 6 SCC 154 in support of his contentions. To submit that the petitioner has been visited with civil consequences as no prior notice was issued to him prior to the authorities recalling the benefits conferred to the writ petitioners. Then we come to the respondent. The respondents have also referred to a judgment rendered in Syed Abdul Qadir reported in so and so. Submit that where the promotion made to the higher post does not carry higher or additional responsibilities, promotional benefits by default, promotional increments by default cannot be permitted. He has also referred to FR 22 in connection with this matter, with this submission. Yeah. Counsel for the parties have been heard, pleadings available on record. Have carefully perused, that when pressed into service. The dispute raised before this court is that petitioner the facts which can be culled out from the submissions made before the court are that petitioner was initially appointed as a peon and subsequently promoted as a senior peon while he was rendering service as senior peon, in view of the selection process undertaken by the APDCL for the post of typist, he, along with other candidates, had applied for and was selected. Subsequent thereto, he was appointed as a typist. Having rendered his services for about 10 years.
More than para 5A says it has to be more than 5 years, less
How
than.
many years as a typist did you work?
I work more than 10 years.
Having rendered services for more than 10 years as a typist, he was subsequently promoted to the post of LDA.
No,
Then-
financial upgradation. I was granted financial upgradation.
Allow us to dictate the facts. Your service chart, you are appointed as typist. Then you are promoted as LDA.
LDA on 15/5/2009.
We are not concerned with the date. From typist, what was the next post?
LDA, which is also called junior assistant.
Was it junior assistant?
Junior assistant,
Junior assistant, all right. It was junior assistant, then senior assistant, then superintendent.
Right.
And subsequently, he superannuated. So, the petitioner, having rendered more than 10 years in his 10 years service as a typist, had claimed for financial upgradation. Is it called MSCP?
No, financial upgradation.
Only financial upgradation scheme.
Scheme, financial upgradation under the scheme.
Financial upgradation scheme, wherein if the employee works for more than 10 years without any benefit of promotion, he is entitled to one financial upgradation. Accordingly, petitioner having rendered more than 10 years of services as a typist and not having been granted any promotion to the next higher post was granted the benefit of one financial upgradation. Subsequently, the petitioner was promoted to the next high post of junior assistant and then senior assistant and finally the superintendent. In each of these promotions, he was entitled to a promotional increment. The respondent authorities decided to recall the benefits granted to the petitioner by way of financial upgradation and also the promotional benefits. So, according to the respondents, the scheme itself provides that any promotion, any appointment to the post of typist or senior typist in a departmental test conducted by the department, and in respect of, where is that?
117.
116 it starts.
Departmental was appointed against any departmental reservation upon the departmental examination. Such appointment will be treated to be a promotion. According to the respondent, since his appointment to the post of typist in terms of the clause 4D of his financial upgradation scheme was a promotion, he is not entitled to the benefit of financial upgradation under the same scheme. Thereupon, in the respect of the promotional increments for promotion to the next higher post of AA, SA, and superintendent, the promotional increments which were received by the petitioner were required to be recalled, inasmuch as that these promotions to the next higher post did not carry additional responsibilities as all the posts were required to do similar nature of work. So, the reference to FR 22 as also the judgment on Abdul Qadir is to the effect that until and unless the higher post subsequent to promotion carries on additional benefits, higher responsibilities, mere promotion by itself will not invite any promotional increments. So, having considered the submissions made and upon careful perusal of the pleadings of the judgments pressed into service and also the office memorandums and the notifications placed, it is seen that the authorities, APTCL authorities, have misconstrued the benefits conferred both under the financial upgradation scheme as also under the FR 22. Under the financial upgradation scheme, an employee is entitled to a financial upgradation if he has rendered services for more than 10 years and he had not been given a benefit of promotion. In the facts of the present case, after his appointment to the post of a typist, petitioner rendered services for more than 10 years as a typist and thereafter was promoted to the post of JA. Therefore, in terms of the scheme, it appears to the court that the petitioner was indeed entitled to the grant of higher financial benefits, not higher financial upgradation, as he had rendered services of more than 10 years in the post of typist before being promoted to the next higher post, which was well after 10 years. Stop. The interpretation of clause 4D cannot be made to include all appointments to the post of typist to the promotion unless the rider embedded in the said clause that the appointment was made in respect of departmental reservations for and conducted through departmental tests was sufficiently was projected that has been sufficiently has been suitably placed before the court by way of relevant documents to show that the test conducted to the post of typist although conducted by the APDCL authorities and thereby even considering it is a departmental test, the appointment of the petition was in respect of departmental, in a post where departmental reservations are there, perhaps for existing candidates employed under APDC. These facts have not been brought out by the respondents. Therefore, these have not been brought out by the respondents. So the petitioner, on the other hand, has also submitted that his name was forwarded by the employment exchange and along with other similarly situated candidates. And in response to the call letter received by the petitioner, he appeared in the written test.
Election test, it was called.
Election test, and was thereafter successfully elected and appointed. Therefore, it cannot be said that the appointment to the post of typist of the writ petitioner was a promotion in terms of office memorandum dated so and so, which is brought out, is relied upon by the respondent. This leads to the second issue of promotional benefits, promotional increments in respect of the subsequent promotions earned by the petitioner to the higher post of AA, SA, and superintendent. No material has been placed before the court by the respondents to say that the posts of JA, SA, and superintendent perform the same nature of work, notwithstanding their different nomenclature. The reference to FR 22 as also the judgment in Abdul Qadir appears to be misplaced in the sense that FR 22 clearly provides that federal increment is not available in cases where the promotion to the next higher post does not entail higher responsibilities. The judgments in Abdul Qadir, the ratio of the judgment in Abdul Qadir is that higher promotion to higher post does not automatically invite promotional increments. Where in terms of FR 22, higher responsibility has not been shown to be undertaken by the incumbent, the department may withdraw or recall or deny payment of promotional. In the facts of the present case, there are no materials before the court paid by the respondent authorities to suggest that notwithstanding the different nomenclatures of the posts, the nature of work of a typist, AA, SA, and superintendent are one and the same and or at least similar. And therefore, no higher responsibility was bestowed, notwithstanding the promotions. And therefore, the petitioners are not entitled to grant to promotional increment as is provided under FR 22 stock. The judgment of Abdul Qadir on the facts of that case was in respect of teachers who claim promotional increment for promotion in the selection grade. Although the promotion in the higher grade, promotion in the higher grade, namely the selection grade of the their assistant teachers, I think.
Assistant teacher.
Assistant teachers. Okay. While it is correct that FR 22 will operate in respect of cases where promotion to the next higher post does not entail higher responsibilities, and in cases like in situ promotions or promotion of assistant teachers to a selection grade offering higher salary but performing the same nature of duties, under such circumstances, promotional increment can be curtailed by the employer. But in the facts of the present case, where the respondents have not placed materials to show that promotion to, notwithstanding promotion to JA, SA, and superintendent, the nature of work undertaken by the petitioner in those higher posts did not entail higher responsibilities than those which he was undertaken, which he had undertaken while rendering his services in post of typist and of the senior typist. Under such circumstances, this court does not find find merit in the contentions of the respondents and the basis on which the financial application and the promotional increments were curtailed. Accordingly, this writ petition is allowed. The respondent authorities are directed to refix the pay and consequential pensionary benefits by releasing the financial upgradation earned by the petitioner and as also the promotional increments during his promotion to the higher posts of GA, SA, and superintendent. And consequently, is the pension required to be refixed?
Yes, last month pay and pension.
Refixed accordingly. This entire exercise we carried out within a period of 30 days,
It be 60 days, madam.
60 days from the date of receipt of a certified copy of this order. Writ petition accordingly allowed, disposed of, no order is imposed.